Yeah. There were a couple ones Zoom. Yeah, no, we had a couple before that, maybe one after that. I don't think you were one after it. Well. Oh, okay. You know what you should have chosen? That.
Township, George. Protect PPDS Spring Township.
Yes.
Zoning hearing board.
Yeah. Not the second or third page. Note that that's what had been done.
exception case?
I'm not sure. Well, conditional use special exception.
This is substantive. Different. Substantive validity challenge is different than special exception or variance. So I'm just trying to process this.
Well, I'm trying to give you an easy night.
No, I don't want an easy night. I mean, I'll take an easy night. I just want to, don't want an easy night to turn into a nightmare.
You won't. That's why I want to do it this way. Less of a nightmare.
So you've written an opinion? Go along with that?
No. Not an opinion. I've written an explanation to the board, and I'm going to read it to the record.
Yeah, they'll pick up.
Okay.
All right, thank you.
Hello, welcome. I come to the house, everybody knows that you're real.
This was.
Good evening. At this time, I'd like to call the February 27 zoning hearing board to order. Please rise for a moment of silence and a pledge of flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, at this time we'll have the roll call.
Mr. Easley?
Here.
Mr. Lazar?
Here.
Dr. Carolyn? Here. Mr. Eichenlaub? Here. Mr. Urogi? And the solicitor is here.
All right, at this time we have the reorganization.
I move that we keep the same roster, appoint the solicitor, Mr. Heisman.
I second that motion.
All those in favor?
Aye.
Opposed?
All right, and at this time, we need to do the appointment of the meeting date and time. Jim, do we need to do anything different than last year?
No.
Okay,
The only thing I would state is December will be the third Monday due to the holidays. Everything else is the fourth Monday.
So that's as stated here in the agenda.
I move that we adopt the, ordinary meeting date and time as set forth in the agenda.
okay, we have a motion, is there a second?
Second.
All those in favor?
Aye.
Aye.
Okay, you have before you the minutes. I would entertain a motion to accept the minutes as presented.
I'll make a motion to accept the minutes as presented.
I'll second that.
All those in favor?
Aye.
Opposed?
Okay, and we have before us the bills, the Time Express attorney. I make a motion, we pay the bills.
Is there a second?
I second the motion.
All those in favor?
Aye.
Aye.
Okay, item number 6 on our agenda, statement by our solicitor.
I'm going to read into the record some material that I sent to each member of the board in preparation for this hearing. Chairman Easley noted that the agenda for Monday's meeting includes a statement of solicitor. Keith called me and asked what this was all about. We discussed the matter and he requested that I send a summary of the proposed statement to all board members prior to the meeting. The meeting contains something that has never been before the board at any time previously, a validity challenge. It is a complicated matter, and the following information may be of assistance to the board. In December 2022, Lower Saucon Township Council passed an amendment to the zoning ordinance rezoning an area to light industrial, which would permit expansion of an existing Bethlehem landfill as a conditional use. This would be, of course, subject to approval by Township Council. Attorney Garber, shortly thereafter the passage of the amendment, filed a conditional use application on behalf of the landfill. Attorney Gary Aztec represents people who are property owners in the vicinity of the landfill who are opposed to the ordinance. Shortly after the conditional use application was filed, Attorney Aztec filed a timely action in the Court of Common Pleas attacking the procedural regularity of enacting the ordinance, saying it was deficient for failing to meet certain technical requirements. Simultaneously, Attorney Aztec filed a timely validity challenge with the Lower Saucon Township Zoning Hearing Board, attacking the ordinance on substantive grounds. On January 25th, 2023, I, along with attorneys Aztec, Garber, and Ling Treadwell, the township solicitor, met at the township building to discuss issues. A number of legal issues were discussed, including the fact that there are essentially three matters pending: the procedural challenge in the Common Pleas Court, the validity challenge before the Zoning Hearing Board, and the conditional use application before Township Council. Attorney Aztec stated his belief that the validity challenge and the conditional use application should be stayed pending the procedural appeal in the Common Pleas Court. This could not be agreed between counsel, and therefore a hearing was scheduled on February 8th, 2023, so that Attorney Aztec could present his motion for a stay of proceedings. On February 8th, 2023, all the lawyers met for a hearing before retired Judge Riedman, who was the motion judge on that day. After a brief hearing, Judge Riedman denied the motion to stay the proceedings. It was then suggested that all the lawyers write to the president judge to have the case given major case status and the judge assigned to handle it. We all wrote letters, and the president judge appointed Judge Abraham Cassis to hear it as a major case. This means that now one judge will hear the entire proceeding and can set aside the amount of time needed to try the matter. Thereafter, I received motions to dismiss from the Bethlehem Landfill Company, raising objections to several points in the validity challenge. After much thought and legal research concerning the MPC and careful consideration of all matters, I am recommending to the board that it strike the validity challenge from its agenda, send a notice of deemed decision to Attorney Aztec, and cause a legal notice to be published in accordance with the MPC. The legal effect of this will be that no hearing need be held before the Zoning Hearing Board. The validity challenge will be deemed by operation of law to be denied, and an appeal can be immediately taken to the Court of Common Pleas. It is clear that whatever this board would decide, an appeal to the Common Pleas Court would be taken. I don't think anyone would disagree with that. The MPC specifically provides for a deemed decision. If a board does not meet certain time limits for holding meetings and or resolving decisions, this results in what is termed a deemed decision. That is, the matter is treated as if the decision was actually rendered. In the case of a validity challenge, which is what is before the board now, the decision is statutorily designated to be a denial of the validity challenge. If the board just did nothing, it could look as though there was an inadvertent deemed decision, that the board failed to act. The procedure of issuing deliberate, intentional deemed decision by announcing that no hearing will be held to consider the matter was expressly approved by the Commonwealth Court, and I cite a case. This was, Commonwealth Court opinion was a 34-page opinion, involved fracking, which raised some of the same issues as this case does. The Commonwealth Court approved the action of the Zoning Hearing Board in the case, issuing a letter stating it did not intend to schedule a public hearing on the validity challenge. This resulted in a deemed denial under the MPC. It is this procedure that I'm strongly recommending to the board. This method of proceeding has been discussed with the zoning officer, James Young, and he has no objection to this. The reasons for this recommendation are as follows. It is clear that this case will be complicated and is beyond the normal matter that have existed and have come before the board. If the board issues a notice of deemed decision, an appeal can be taken immediately. This case can be consolidated with the case that has already been declared a major case by the Common Pleas Court, and a more orderly procedure will follow. For example, the Pennsylvania Rules of Civil Procedure do not technically apply to zoning hearing boards. There have already been 2 motions to dismiss, as well as a motion to quash subpoena filed with the board in accordance with the Rules of Civil Procedure. The board would have to deal with these in some fashion. Also, the MPC provides that formal rules of evidence need not be heard by the board. But it is also true that irrelevant matters should not be heard. I anticipate a great deal of arguing over procedural and evidentiary issues, which a court is better equipped to handle. Among the other legal issues I can foresee is who should be heard by the board, who has legal standing. As the matter will take an estimate 5 or 6 hearings, each of 3 or 4 hours duration, What happens if a board member is unable to attend one of the meetings? If a zoning hearing board upholds a validity challenge, it must then provide detailed findings concerning recommendations of how the ordinance can be adjusted to meet the objections, including such things as road usage, sewer facilities, water supplies, and public service matters, which are difficult and technical legal issues which do not come before the board in the usual course of its normal business. The advantages to the notice of deemed decision being issued is that it will conserve township resources, avoid many problems, allow constraining the case within the major case pending in the Northampton County Court of Common Pleas for a unified result, ensure fairness to all parties, and result in a more efficient process to resolve the issues. It is therefore my recommendation that the board move to strike the validity challenge from the agenda and authorize the chairman to sign the proposed notice of deemed decision, a letter which I included with my material to the board. Finally, I attach the proposed letter for signature by the chairman, which will completely and finally properly resolve the case before the board in accordance with its duty under the MPC.
Before the board acts, may I make a statement, Mr.
No.
Solicitor?
No, this is board business as to which there's no public input.
Well, I'm not the public, I'm the applicant. We are here this evening. This hearing has been scheduled. Notices have been issued. I presume posting has occurred by the zoning officer. And we are here this evening ready to proceed with witnesses on a substantive validity challenge filed pursuant to the Pennsylvania Municipal Planning Code.
Not to be heard at this time.
I'd just like the record to reflect
The
that we
record
are
to
here
reflect that.
ready to proceed on a duly advertised hearing, and I would not want whatever actions the solicitor is recommending to prejudice the appellants in this matter. It is my understanding, reading between the lines, that it is the intention of this board to literally abrogate its responsibilities and punt the matter to the Court of Common Pleas. I do not want it to be interpreted that this would deprive us of a right to be heard or deprive us of our right of due process to raise the constitutional and substantive issues that are raised in our pleadings.
It does not and it cannot deprive you, because it's a non-decision. It's deemed by the law. What the board is going to do remains to be seen. We had to advertise and had to bring everyone here. So whatever the board does is done in public, and it will be done in public with a vote.
We have a room full of people.
I understand that, and they have a right to be at a public meeting, which is occurring. They have a right to listen. They know they have a right at this point to participate. So at this point, I am calling upon some member of the board to make a motion.
May I ask a couple of questions?
Of course.
First of all,
You have to press the button.
okay, first of all, Mr. Heitzman, I would like you to state whether or not, I think you have sort of, but that the procedure you are proposing will or will not prejudice any party, give a party an undue advantage or disadvantage, that it's completely neutral, and it will go to the court, which is going to decide the matter without the board being anything other than neutral.
That is
correct?
exactly right.
Okay. Question number two, if we go along, if we adopt your proposed procedure and make the decision that you have drafted, is it possible and is it worthwhile to include your statement either as a preamble or a whereas clause or in accordance with the attached, to avoid any doubt as to what we're doing tonight?
Well, my statement is on the record, so that is the record that is being presented before this board. So that will be available to any party who wants it.
Will the solicitor provide counsel with copies of what you read into the record to facilitate the appeal that is sure to follow?
I'm glad you agree with me, an appeal is sure to follow, and of course I will give you a copy.
Thank you very much. And Attorney Garber and of course, Mr. Trickle.
And I gotta get 3 copies?
If you send it to me,
Okay.
Mr. Heitzman, I'll provide them with copies.
I will provide copies to everyone, of course.
And I would say in the spirit of deliberation of the board, that it seems to me that this is the most efficient way to handle this, the best way to handle it. And I'm inclined to vote for it unless someone comes up with a reason not to.
May I suggest a motion for him?
That would be very helpful, thank you.
The motion is that the substantive validity challenge on today's agenda will be stricken from the agenda, and notice of deemed decision in the form that I've already given to the board will be issued to Mr. Aztec this evening and all parties, and it will be published, thereby given public notices required for a deemed decision. That's the motion.
Before we have a motion, I have a question. If we hear this, and if we make a vote, irregardless of how this board votes, if I understand what you said, one side or the other will appeal.
I guarantee that.
So, to take what you recommend makes it more efficient to go ahead and get the appeal.
I agree.
Is that true?
That's my basis.
Okay. Any other board members have any questions or comments?
I agree with what you just said, and I think the key from my standpoint is what we're doing tonight does not in any way prejudice or color the decision then that's made in the court.
Right, that's what I see it. Yep.
Did someone adopt that motion, John?
I would propose we accept the motion, or propose we vote on the motion that the solicitor just provided.
And is there a second?
I'll second.
All those in favor?
Aye.
Opposed? Motion passes by a unanimous voice vote.
Boo. Okay. Jim, we'll ask you at this time, do you want to present the old business?
I don't believe there is any old business.
No old business, how about new business? Okay. Okay. Anybody make a motion we adjourn? Okay, motion is made we adjourn, is there a second?
Second.
Aye.
Aye.
Thank you.
From back in the Northampton County Court, Thomas Lee. Thanks for everybody that watched. Not Floyd and Glenn, if you're still here. I don't know. The press doesn't give me that. I just see that for watching. Well, thanks for watching. The only problem is when those of us in the County Court come to please, we're not going to be able to do it. They will allow cameras to try to give you a I hope you enjoyed that. On here, on YouTube. YouTube is live. Also, to find the camera recording and upload that into later stage. It takes a lot to process. So enjoy it. I'll just leave it on so you can enjoy the show.
Yeah. This is in
Signing off.
You got it covered. You got it covered, I promise. I know where I get it from. So, all right, you're good to go. All right. Yeah.